Is there ever an instance where the defense will withdraw their settlement offer? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is yes, there is an instance. There could be many instances where the defense will actually withdraw their settlement offer. So let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. And now the defense initially said, hey, listen, why are you suing us? We did nothing wrong. And then they say, you know what? If we did something wrong, whatever we did didn't cause or contribute to your injuries, Mr. Patient. And then they'll say, you know what? If we did something wrong, so did you, Mr. Patient. And then they'll say, you know what? If we did something wrong and whatever we did caused your injuries, guess what? Your harm really isn't that bad. You weren't that badly hurt. Those are the typical defenses we find in these types of cases. And then they say, hey, you know what? We are never going to negotiate this case. We are never going to settle with you. We'll see you at trial. And that means you're going to go through the litigation process, which could take 2 to 3 years. That's how long these cases take here in New York. Okay, fine. So now you go through the litigation process. And as you are getting closer and closer to your trial date, all of a sudden your attorney tells you that the defense has contacted him and now is willing to negotiate. And you think, okay, that's great. How much are they offering? Now your attorney begins the negotiation process, and he comes back to you a little while later with a particular settlement number. And you go back and say, absolutely not, that's outrageous. So now, your attorney relays that information to the defense attorney. And what happens next? The defense attorney may turn around and say, listen, that settlement offer is valid for this amount of time, for the next few days. And if your client is not willing to accept it, well, guess what? We're taking the offer off the table. That is a negotiation strategy. Does it happen often? No. You will find that most reputable defense lawyers and most reputable defense insurance companies do not play that game. If they make an offer to try and settle the case, it means that they're willing to try and negotiate. Why? Because it's a risk. It's a business decision, and now they're willing to make a calculated risk to try and get rid of your case for a specific amount of money that they believe is less than what a jury would ultimately come back with at the end of a trial. And what they would then have to pay in expenses and attorney's fees and to go through another trial or to go through an appeal. In that instance, they are making a calculated risk about whether or not it's worthwhile to try and settle the case before giving it to a jury where really nobody knows what's going to happen. The fact is, when your case goes to jury trial and a jury ultimately reaches a verdict, you don't know what the outcome will be. Your lawyer doesn't know what the outcome will be. The defense lawyer doesn't know. The defense's insurance company doesn't know. The judge doesn't know. So you leave it in the hands of 6 people whom none of you know, and now they will make a decision about whether or not you are slightly more likely right than wrong that what you are claiming is true. And then everybody has to live with that verdict or try and reduce it or get it thrown out or appeal it or have a new case. And there could be many different options once a jury reaches a verdict. So by making a settlement offer, each side is now willing to negotiate to see if it's possible that each side can control the risk. The defense wants to do everything possible to control the amount that they have to pay out. Your attorney wants to control knowing how much money he can ultimately get for you without having to go to trial. And if the 2 sides can reach an agreement and everybody agrees on it, terrific. Now that's guaranteed money in your hand. You don't have to worry about what happens with the jury and what will happen afterwards. Some defense attorneys, after going back and forth with now negotiating the number, now may come back and say, listen, your client is being totally unreasonable. If your client doesn't see the value in what we are offering, then guess what? We will withdraw our offer as if we offered 0. Absolutely 0. And then you'll have no choice but to go to trial and to go ahead and take the risk of having a jury reach a verdict. That is one possible settlement strategy. Does it work? It can work. It can put a tremendous amount of pressure on the injured patient to make a prompt decision about whether or not they will go ahead and accept it or take what's behind door number 2, which is an unknown. You don't know what's going to happen. Your case could take 2 or 3 weeks to try. Your attorney could spend $50,000 or more or less to go ahead and bring in all the different experts and to prosecute your case and your trial. And guess what? You may wind up with less money than what is being offered. You may wind up with a similar amount or even more. And clearly, if you wind up with more, there's a very good chance the defense is now going to appeal that particular decision and that particular verdict. So why do I share this great information with you? I share it with you because I want you to understand what does in fact happen from time to time in these civil lawsuits involving accident cases and medical malpractice cases and even wrongful death cases here in New York. You know, I do understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and still have questions that need to be answered, then what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.